Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Esiedu Entry, and today we are looking at an editorial on the case of Parte Kevin Ekow Taylor. Parte Kevin Ekow Taylor. If I may even take you through the full title of the case, it is the Republic versus the High Court Commercial Division, Parte Kevin Ekow Taylor, with Attorney General as the interested party. Now, this is a decision that was given by the court on the 22nd day of July 2025. And when we talk of Parte Kevin Ekow Taylor, I believe that most of you know the facts that surround this, but it is only prudent that I give you the detailed facts of what actually occasioned this case or this action that was brought by Mr. Kevin Ekow Taylor. So the case of the Republic versus Eugene Bafuboni and four others, which was around some issues at the National Communications Authority in the Mahama #1 administration, which when the Akufo-Addo #1 administration took over, now sought to prosecute certain board members together with some officials at the National Communications Authority. In that case, that is when that case is so revealing and telling that it has brought what we call a landmark principle, or establish a landmark principle in our criminal jurisprudence, leading to the fact that that case has now settled that in any criminal prosecution or criminal trial, there must be a full disclosure. When I say full disclosure, when you go to court or when you are arraigned before court, your charges are read to you. You plead either guilty or not guilty. So mainly when you plead not guilty, and let's say the full fact of the case is read to you, then you apply for bail. The next thing you must do before the case conference is disclosures. And when we say disclosures here, we mean that the prosecution, the one who is prosecuting the accused person, must disclose all the necessary evidences that he has, the necessary evidences in his stead, even including what we call exculpatory evidence. What I mean by exculpatory evidence is exculpatory evidence are those evidences that will help even the accused to exempt or not to be convicted. It will benefit the accused rather than the prosecution. So even if the prosecution has those exculpatory evidence, he must disclose it. The very purpose of disclosure, which actually arise out of the case of the Republic versus Eugene Bafuboni and four others, is to prevent what we call surprises in our criminal prosecution. So just imagine that if there are no prosecution disclosures, and let's say the prosecution start to prosecute, you will be there and the prosecution will just come out with a certain evidence. You are not even prepared. The accused person will tell you that, oh, let me go and examine the evidence. You will come back. It will take a number of years and it will drag the criminal prosecution. So this case, Republic versus Eugene Bafuboni and four others, has settled it. And now, as we all know in our criminal jurisprudence, most especially those in the legal space, now understand that you need what we call disclosures. You need to do what we call disclosures. Now, in the said case, Mr. Kevin Ekow Taylor was seen on television making certain comments, an alleged comment. Also, let me put it that way. I don't want to settle on it that it was Mr. Kevin Taylor that was actually saying that, because it is not an established fact in the proceedings. So allegedly, he was seen making certain comments that impugn or denigrate the image of the court. And as such, Mr. Justice Cheba, who is a Court of Appeal judge, sitting with an additional responsibility as a High Court judge in that case, issued a bench warrant for his arrest. And for the purpose of our learning, I'll read the bench warrant. It says, warrant for arrest of Kevin Taylor, Kelvin Taylor, as you find it on your screen. It says, and whereas the court's attention has been drawn to a scandalous video circulating on social media in relation to this case, the case, the Republic versus Eugene Bafo-Boni and 4 others, which video contains an extremely scandalous and a prima facie contemptuous speech which that scandalizes the judge, the court, and the whole administration of justice. And whereas this scandalous video is purported to have been made by a scoundrel who styles himself as Kelvin Taylor, who is not a party to this case, and the court finding it necessary to invoke the powers vested in it under Article 126 Clause 2 of the Constitution 1992 to proceed against the scoundrel Kelvin Taylor for contempt. Now, therefore, the court orders the issuance of this warrant for the apprehension of the body of Kelvin Taylor and for him to be produced before the court to answer the question why he should not be committed to prison for making such contemptuous statements, which are totally a fabrication by him in the said video. It is thereby further ordered that this warrant is directed at the Inspector General of Police, the Ghana Police Service, the Bureau of National Investigations, and the National Security to take appropriate steps for the apprehension and the production of the said Kelvin Taylor before the court. It is further ordered that this warrant remains in force until Kelvin Taylor is arrested and shall lapse the day the said Kelvin Taylor expires from the surface of the earth, meaning until Kelvin Taylor expires or dies from this earth, the said bench warrant is in force. So the bench warrant was issued based on a certain contemptuous statement allegedly made by Kelvin Taylor. But remember, I mentioned that the case is ex parte Kelvin Taylor, but in the warrant of arrest we have Kelvin Taylor. But I want to explain something to you. Contempt. He's made a contemptuous statement, a statement that denigrates the administration of justice, basically, or that denigrates the court, or that speaks ill about the judge who is adjudicating any matter. And in Ghana, if you read Article 126 of the Constitution, Clause 1 says that there are 2 types of courts. We have the superior court and we have the inferior court, or say the lower courts. When we talk of the superior court, we are talking of the High Court, the Court of Appeal, and the Supreme Court of the Republic of Ghana. Now, these are the superior courts. They are what they are termed as the court of record, meaning their decisions they make becomes a binding precedent other court must follow. With the lower court or the inferior courts, they are not court of record. So that is the difference. And as a court of record or the superior court, per Article 126 Clause 2, have the power to commit to themselves contempt. Now, contempt is a criminal offense. But since it is a criminal offense, ordinarily, all legal students or law students will be thinking of looking at the nolim crimen principle. And when I talk of the nolim crimen principle, people will be thinking that Article 19 Clause 11 must apply. And what does Article 19 Clause 11 say? That before someone will be convicted of a criminal offense, such criminal offense must be defined with an attached penalty stated in written law. But contempt is not really stated in written law. So there is a procedure that goes by, what we call that the court goes by in dealing with contempt. Meaning contempt is an inherent power granted the court to ensure that there is judicial sanity in our country or in any legal system, so that nobody can stand anywhere to scandalize the court. So basically, when the court issues contempt against you or issues an order of contempt against you, all that it means is that one, the court determines per their discretion to ordinarily give you the punishment they believe or think it so fits the situation. If you read Article 1911, as I've already stated, it means that for something to qualify as a criminal offense in our country, it must be defined and the penalty attached in written law. So let's pick stealing, Section 124 of our Criminal Offences Act or let's say section 149 of our Criminal Offences Act, robbery. You know, robbery is a first degree felony, and first degree felony, the understanding is that per the its punishment, it is, you can be committed to prison for life imprisonment or any lesser term. So the highest you can go is life imprisonment or any lesser term. But contempt, you don't know the punishment attached to it. And so even though it does not qualify under Article 1911, there is the power given to the Superior Court to purge the court from anything that is not seen or anything that scandalizes the court. So it's an inherent power of the court. So you can look at examples of, say, this former General Secretary of the MPP. You can look at that is Sir John Kwajo Owusu-Afriyie during the 2013 election petition. You can look at Samuel Kwabena, who is now a lawyer, on how he was actually ordered by the court with regards to his contempt case. He's now a member of parliament for the good people of Equiapem North. You can check the Muntie 3, where they spoke against these three gentlemen, Mugabe, Marseille, and some two others, if I'm not getting the name wrong, spoke against the Chief Justice and others and how they were committed to prison in that regard. So basically, when you speak against the court or you scandalize the court, you are committed for contempt. And the procedure is very simple. If you read Order 50 of the High Court Civil Procedure Rules 2004, CI 47, which is the short form as we call. Order 50 talks about the procedure you need to go through. One, either when somebody scandalizes the court, it is one of two ways. Either I am a party, so there is an issue between myself, Eronasi Eduentry, as against my sister Risa Iris Ewonia. We are in court. I'm the plaintiff, she's the defendant, and she goes or stands somewhere to scandalize the court, or the court gives an order against her, she fails to obey the order. I will now go upon an application to cite her for contempt for disobeying the court orders. That is one way. The other way is that the court itself calling you to come and appear before the court for contempt. And so when I cite her for contempt, in the first way, or the court calls you, all that the court intends to do is to invite you to come and explain as to why you should not be committed to prison. So you explain yourself that, oh, this so and so allegation has been made against you. Tell us or tell the court why you should not be committed to prison. That is basically the contempt procedure. Now, why is Kevin Ekow Taylor in court? He was cited for contempt, I think, on the, if I'm not getting it wrong, on the 16th day of January 2020. 2020, some 5 years and over ago. But the point over here is that when you want to apply for what we call judicial review, as Kevin Ekow Taylor is doing, the rules of court is saying that you have 90 days upon the action arose to bring an action. So if you are cited for contempt and you want to, if you are cited contempt today and you want to go to the Supreme Court for a judicial review matter on it to quash the decision by the High Court, clearly you have 90 days to bring an action. But from 16th day of January 2020 to 2025 will tell you that the 90 days has lapsed, and now it is even eating into maybe a decade or so, 5 years and over, meaning there are a lot of days. But Kevin Ekow Taylor's argument is very simple. One, he does not live in Ghana, he lives in the USA. And now the point over here he's making is that he got the information from friends and associates in Ghana who couldn't provide the order to him. So he did not see the order. And if he's not seeing it, rightly so, maybe it would not really make sense that an order that has not been provided, or what we call that has not been given to me, why would I even bother myself? Maybe his presumption, that is his presumption. So his argument is that, one, he has not seen the order. Now, 5 years later, he believes that no, the description of whatever everything he's been told is pointing to him. So he has to take an action to that effect. And so he's in court telling the court that for the High Court Justice to issue a bench warrant for his arrest means that the High Court judge is breaching his fundamental human rights in a simple term, which means in a simple balance or a simple meaning. What he's trying to tell us is that if you want to cite me for contempt, you don't tell them to arrest me. If they arrest me, they will restrict my freedom of movement and others. And I believe that if you do that, you are breaching my fundamental human rights. You should actually make an order for me to appear before you and explain why I shouldn't be committed to prison. That is basically the argument of Kevin Ekow Taylor. Now, Kevin Taylor is in court. The Attorney General is an interested party who must speak ordinarily on behalf of the court, because the Republic versus High Court Commercial Division, as Parte Kevin Ekow Taylor, Attorney General, as interested party. So the AG must be speaking on behalf of the state in regards, quote unquote, on behalf of the judge to defend. The most surprising thing is that one, the AG did not enter appearance, and two, he did not even go to court, the AG's team, which was surprising. And if I may read what the judge actually mentioned in regards to that, it says no opposition. It is a paragraph 20. It is trite legal knowledge that there is no statutory obligation on an opponent to an application to file an affidavit in opposition. So it is not by force that the AG should be filing, an application or oppose the application filed against the AG. Indeed, an application may be opposed without the necessity of filing any formal affidavit. You can even walk to court and say that you are opposing. You don't necessarily need to file anything. Now, the point over here is that the court is saying that, one, the AG did not file any opposition. Two, the AG did not even step foot in court when the matter was being determined. And so the court found out that out of deference, the AG should have actually even make an appearance and tell them that, well, we don't even oppose. And so Justice I.O. Tanko, who led the 4-1 majority ruling, said that we note with regret that there was no appearance in court by or on behalf of the Honorable Attorney General, even if only out of deference to this court, to make an appearance and concede that the procedural shortcomings raised in the applicant's statement of case are unanswerable, or alternatively raise point of law in opposition to the application. So the court is saying that even if you have no opposition to the application brought by Kevin Ekow Taylor, you should have only come to court to tell us that it is unanswerable. That would have been out of deference, but the AG did not do that. Far from that. Now, Kevin Taylor's argument on the 90 days, which is the actual timeline given by the rules of court, the Supreme Court, the CI16, the Supreme Court procedural rules they use to deal with procedural matters or civil matters in court. Kevin Taylor says that, well, I did not get the actual order from the 16th day of January to 2020 till 2025. It is only out of respect of the court, Kevin Taylor is saying, that he chose now to commission his lawyer or hire the services of his lawyer to go and make the search. And it took, I think, a month or two for the lawyer to even find the order that has been issued against him, Kevin Ekow Taylor. And even with that, when he found the order, he saw Kelvin Taylor, not Kevin Taylor, Kelvin Taylor. But for him, he believes that definitely it is being referred to him. So he's in court that bench warrant will breach his fundamental human rights. There should have been an order issued by the court to demand his presence to explain why he shouldn't be committed to prison, not necessarily a bench warrant. Now, the court, in a 4-1 decision led by Justice I.O. Tanko, if I'm getting the Tanko Amadu, stated clearly, the court in a 4-1 ruling led by Justice Tanko Amadu, JSC, or a justice of the Supreme Court, that is what JSC means, stated that with regards to the timeline, Kevin Taylor was tardy, meaning he's at fault. He decided not to come within that period. Because if you are saying that people are mentioning it to you and you deem it necessary to clear your name, it shouldn't have been 5 years. It should have been the period you were hearing from your friends. However, they believe that the substantive matter or the actual matter before them would not necessarily have to be based on the timelines for them to say that they will not look into the matter. So, in the actual matter, Justice Tanko started with the ruling with a prologue, and I like it so well, I want to read it to you. That there cannot be anything of greater consequence than to keep the stream of justice clear and pure, that parties may proceed with safety both to themselves and their characters. This is per Lord Hardwick in the St. James Evening Post case, 1742, 2 Atkins, page 46 to 40, page 469 to 472. All that he was trying to mean was setting out a ruling in an 80-paragraph majority opinion. 80-paragraph majority opinion. The case in itself is 44 pages because there is a dissenting opinion by Justice Gewu, who also dissented in about 8 pages. But this is an 80-page solid majority opinion given by Tanko Amadou JSC. The crust of the ruling is very simple. 1. Justice Tanko says that indeed it is a breach of the fundamental human right of a party who purportedly has committed contempt. What does it mean? He says that when it comes to contempt or judicial review matters, all that the court is looking at is the procedural propriety of the process. When you go to court, there are 2 things you look at: the substantive law that is being discussed in court and the procedural propriety. The substantive law and the procedural propriety. So even when you have committed an actual illegality or you've committed any offense against the state and you are not taken through the due process of law, you can be freed. So the fact that the words that were said and displayed on TV whatsoever was actually contemptuous or scandalizes the court, the process to get the person who made those contemptuous statements must follow actual due process of law. And so the court said, through Tanko Amadou JSC, is saying that for you to issue a bench warrant is totally wrong, as it will infringe on the fundamental human rights of the said party. What if you arrest the person comes, is able to explain to the court that indeed he's not even the one who uttered the said words, and maybe it is AI or IA, dependent on the generation we are in now. So Tanko Amadou JSC brought a procedural, or actually established a procedure in this case as to how contempt issues should be dealt with. 1, he says, A, first cause to be issued a summons or order demanding the presence of the alleged contemptor to show cause why he should not be committed for contempt. So first, issue a summons or order the person to come before you. 2, the summons should simply contain a statement demanding appearance before the court to show cause without more. So do not make certain statements within the summons, maybe describing the contemptor with certain names. Like if you check the bench warrant, you get to know that the Venerable Justice Chebafo used the word scudrel. Probably the court was not happy using that because it makes the matter already prejudicial. 3, prejudicial statement or words likely to be construed as prejudicial should not accompany the summons to show cause. I've already explained that. So 1, issue the summons. 2, the summons must only contain an order to invite the person to come and show cause. 3, the summons shouldn't contain prejudicial statements. 4, it says that the registrar of the court must ensure that the alleged contemptor is duly served with the summons. So in this case, as Kevin Taylor was saying that he was not served, probably somebody may get away by saying that I was not served. And E, in the event that the alleged contemptor is duly served, yet refuses to appear before the court, then the court may decide to issue an arrest warrant. Even at this stage, the court must assess all the circumstances of the case impartially and first determine whether the default in the appearance was not occasioned by any special circumstance which made it impossible for the alleged contemnor to appear. And the exercise must be guided by the principles of fairness, especially as defined under Article 296 of the 1992 Constitution. So the court is saying in the fifth point that even when you issue the summons and the person refuses to come, then you have the right or the capacity or the ability to now issue a warrant of arrest. Even with the warrant of arrest, assess why the person did not appear due to your summon. Maybe there might be a special circumstance that prevented the person from coming to the court. So basically, the bench warrant issued against Kevin Ekow Taylor was quashed. We don't say quash. I learned it from a colleague who completed Wesley Girls. Think Kimi Odum. I'm sure if she's watching this, she'll be smiling. Kimi would always try to bring new words. She says quash. We don't say quash. Makes it difficult for those who went to certain secondary schools, but that is fine. So the court quashed the bench warrant and stated this new procedure that first, issue a summons or an order for the person to appear. 2, the summons or order should only contain statement ordering the person to appear. 3, the summons or order should not contain any prejudicial statement or words. And 4, the registrar of the court must ensure that the summons is served. And 5, it is only when the summons is served and the person refuses to come that you can now issue what we call the bench warrant. Even with that, the court is entreating you to examine the circumstances so that you can actually know that indeed the person, something actually prevented the person or the person deliberately did not come before you can issue the bench warrant for the arrest of the person. Then again comes Justice Gewu, who gave what we call it. The name is Jaewu, Gewu, JSC. And I'm pleading, my Lord Justice Gewu, if I'm not pronouncing the name with all due respect, forgive me. He gave an 8-page dissenting opinion, not agreeing with the other 4 parties. Now, what he's saying is that it was quite deliberate for Mr. Kevin Ekow Taylor not to bring an action within the 90 days. Because if he had actually meant it as he's brought it now, he was only tardy. And if you were tardy, he believes that we shouldn't be looking at the matter now. The bench warrant should have been enforced. That is basically the crux of his dissenting opinion. So in an 80-page paragraph majority opinion, 8-page dissenting opinion, total 44-page ruling, a 4-1 decision in favor of Mr. Kevin Ekow Taylor. Ladies and gentlemen, this has been the Law Lab. Here we dissect and unpack everything legal. My name again is Aaron Asiedu Entry, and I thank you for your time.